Welcome to Lesson 3 of AJS109, Substantive Criminal Law. This lesson is Criminal Defenses Part 1. So let's begin with what is a criminal defense. A criminal defense is an argument made in court by a defense attorney asserting that a person should not be held criminally liable for an act based upon a legally recognized assertion that eliminates criminal liability. In other words, the defense is in statute. It was passed by our legislature, signed by the chief executive, and it is part of statutory law, and the statute specifically details what the defense involves. By the way, if a person successfully asserts a criminal defense and is not found criminally liable, it does not relieve possible civil liability. Remember, criminal and civil courts are separate. You can be found not guilty of a criminal charge and still be sued civilly for damages and have to pay. They're two separate things with two separate standards of proof, and in addition, they also have different purposes. Criminal law is to punish, civil law usually is to compensate for injuries or other harms done. Okay, so let's get into the two major groupings of defenses: regular defenses and affirmative defenses. In most cases, the prosecutor must convince the jury that the defendant committed every element of the crime. When the burden of proof rests with the prosecutor, we call it an ordinary defense. And the burden of proof on the prosecutor in such cases is proof beyond a reasonable doubt. The most common ordinary defense is called the alibi defense. It's an assertion that the defendant did not commit the crime, or at least that the defendant doesn't think the prosecution can prove to the jury beyond a reasonable doubt that he or she committed the crime. And that's an ordinary defense. In such situations, the defendant doesn't have to even testify before the court. It's the prosecution that has to prove every element of the crime beyond a reasonable doubt. But in some cases, the defense asserts that something about the defendant or something about the situation should relieve the defendant of criminal liability, criminal responsibility, or at least lessen it. Then the burden is on the defense to prove it. And we call these defenses that rely on something about the defendant, something about the situation, and where the defendant has to prove it, we call these affirmative defenses. And within the category of affirmative defenses, we can divide them into two types: justification defenses and excuse defenses. In both justification and excuse defenses, the defense admits that the defendant committed the crime, but asserts that no criminal liability exists. In a justification defense, the defense asserts that while the defendant broke the law and the prosecution can prove it, it was a good thing to do, or at least it was the better thing to do, and the law specifically recognizes that. Examples of justification defenses include self-defense, defense of others, defense of property, making a lawful arrest, and necessity. Remember, the defense attorney is going to tell the jury, yes, my client broke the law, but under the circumstances, it was a good thing to do. That's a justification defense. The action was justified. It was just. On the other hand, in an excuse defense, the defense asserts that while the defendant broke the law and it was a bad thing to do, something about the defendant or the situation should negate criminal liability. Now, excuse defenses based upon something about the defendant include infancy. The defendant was too young to be liable, too young to form a guilty mind. Or the defense of insanity. The defendant, because of a mental disease or defect, can't reason properly, didn't know what they were doing, didn't know it was wrong. Excuse defenses based upon something about the situation include coercion. The defendant committed the act under the threat of harm if he didn't, or entrapment. The police used unfair tactics. Mistake of law. The government misled the defendant about the legality of the act. And mistake of fact. The defendant made a reasonable factual error. The self-defense defense applies when the defendant has a reasonable belief in the immediate necessity to use force against another to defend him or herself against the unlawful use of force. So let's take a look at each element separately. The first element is, has a reasonable belief. The key word here is belief. The law of justification is not concerned about the reality of the situation, what actually is going on. Whether the defense applies to someone is based upon what that person reasonably believes. For example, if a person approached a police officer holding what appeared to be a gun, said, "I'm going to kill you," and began drawing the gun at the police officer, and in response the officer pulled his or her gun and shot that person, and it was later found to be that the gun they were drawing was a replica toy gun that looked just like a real gun, or was a real gun, but it could not operate and shoot, the officer could still use the defense, because even though in actuality there was no threat to the officer because the gun didn't work, the officer in those circumstances reasonably believed that it was an operable gun, so this element is met. I should also mention that this is an objective standard. So it's not how reasonably the belief is in the mind of the person using force who wants to assert the self-defense defense. The question of the reasonableness of the belief will be decided by a prosecutor reviewing the case, or perhaps a jury if it goes to trial. And the standard will not be how sincerely the person who used the force held that belief, but whether with the same facts, hypothetical reasonable citizens would also have concluded that the belief was reasonable. That is an objective standard. What would society believe, as opposed to a subjective standard? What did that individual believe? The second element is in the immediate necessity. The use of force has to be immediately necessary in the mind of the person using this defense. The force has to be occurring or about to occur any moment. The person is in fact coming at the person with a knife or beating him with fists, or the person is perhaps reaching for a gun or reaching for a knife. It has to be imminent. If a person says, "I'll get you, I'm going home to get my gun and shoot you," that is not an immediate necessity situation, because the person has to go home and get the gun. You have time to leave to call the police. So the use of force has to be immediately necessary. The force must be occurring or about to occur. The next element is to use force against another to defend him or herself. You must be threatened to use the self-defense defense. And finally, the use of force against you must be unlawful force. If it's a police officer legally using force against you to arrest you, then you cannot use this defense. Somebody has to be using unlawful force against you to trigger the self-defense defense. Now, some other important points. The force used must be proportionate to the threat. You cannot use deadly force, and deadly force is force capable of causing death or serious physical injury. You cannot use deadly force when you're only being threatened with non-deadly force. However, you can use overpowering force. You can use more non-deadly force than is being used against you, so you overpower the person. But you can never use deadly force when you're only being threatened by physical force. Now, in many states, not Arizona, you must retreat if safe to do so before using deadly force. Unless you're in your home, and that's the castle doctrine, which says you can stand your ground in your home to defend yourself. before using deadly force, or in some states, your workplace. But Arizona is a stand your ground state. You are in no obligation to retreat before using deadly force if you're justified to use deadly force in self-protection. You don't have to retreat if safe to do so in Arizona. You may stand your ground. And the theory behind that is that while you may think it's safe to retreat, maybe it isn't. Maybe you're exposing yourself to danger. So in Arizona, we didn't want to expose decent people to the threat of being shot as they fled when they might not have to. Another important point is that you must stop using force when the threat ends. If the person that you're using force against suddenly calls up in a ball and is surrendering, you can't continue to hit them. Now, the law doesn't expect you to behave like a light bulb and just click yourself off. But once the threat stops, you have to stop as reasonably as possible. Now, practically, but not necessarily legally speaking, it is best to retreat before using deadly force, even when you can legally use it whenever it's safe to do so. If you can safely retreat, then call the police and have them come after the person who's threatening you or who used force against you. If you can safely retreat, then you risk not only all the legal hassle that goes with having to assert the self-defense defense, maybe even in court, but you also don't expose yourself to being killed or hurt yourself because you're avoiding the fight. So even if you can legally use force, my personal advice is if you can safely retreat, then get out of Dodge. You'll be better off all around, in my opinion. The self-defense defense is sometimes asserted by battered women who kill their spouses or other significant males in their lives who regularly beat them or otherwise abuse them, but when they are not under imminent threat of serious injury or death. In these situations, the women possess a fear born to being battered or abused regularly by that spouse, and a fear that that spouse will attack again, but sometime in the future. And that is not imminent fear. If the woman was being battered regularly and the spouse again was about to or started to batter them, then they could use the self-defense defense. But in the situations we're talking about here, there's ongoing battering, but the woman is not being threatened or actually battered when she uses the deadly force against the husband or other male. Now, battered women's syndrome is a recognized condition by the courts that accounts for women remaining in such abusive relationships, and expert testimony is permitted about this syndrome. You have some women who are repeatedly battered, and because of a variety of personal and sociological and psychological factors, they remain in these situations, exposing them to battering. It's a psychological problem. Now, when a battered woman defends herself against imminent occurring force, or actually occurring force, the use of force in self-defense is justified. However, in cases where the woman was battered, the spouse then goes to bed afterwards, and the woman then kills him in his sleep, the defense usually will not apply. Likewise, a battered woman killing her spouse as he arrives home from work, anticipating a beating later that evening, would usually not trigger a self-defense defense. In other words, when battered women injure or kill the person battering them, and the use of force was not imminent, the threat was not imminent or occurring, the battered woman defense generally will not shield them from guilt. Now let's talk about the defense of others' defense. Generally, the same rules apply when using force to defend others as apply to self-defense. However, in some states, it is only justified when the person being defended could legally defend himself or herself, while other states allow legal force usage in defense of another when the intervener reasonably believes the person being defended could legally use force. In any event, be very careful in intervening in situations when you come to the scene late. The person on top of someone hitting the other may be the victim who is stronger and is using the force legally. And the guy holding a gun chasing someone might be a cop in plain clothes. Arizona law has a very brief justification for the use of force of a third party to defend another. It's Title 13, Section 406. And it says a person is justified in threatening or using physical force or deadly physical force against another to protect a third person if, under the circumstances, as a reasonable person would believe them to be, such person would be justified under Section 13404 and 405, that's self-defense, in threatening or using physical force or deadly physical force to protect himself against the unlawful physical force or deadly physical force a reasonable person would believe is threatening the third party. So in other words, you can intervene in Arizona and use force to defend somebody else if you reasonably believed that if you were that person, you could use that level of force to defend yourself. Again, if you weren't there from the beginning, be very careful and make sure you have the facts correct, because it's very easy to mistake the good guys from the bad guys and the cops from the bad guys. And that would be a real legal problem if you did that.